Been spending most our lives living in a gangster's paradise. Been spending most our lives living in a gangster's paradise. Keep spending most our lives living in a gangster's paradise. Keep spending most our lives living in a gangster's paradise.
3, 2, 1, roll 5.
In the name of God, the compassionate, the merciful, welcome, friends, to Crime and Punishment, a legal podcast, not a political one. The podcast of the Invictus Law Firm, PA, a criminal defense law firm in Orlando, Florida, the website for which is Augustusinvictus.com, and that is me. Yours truly, the host of this program. Also, the person who did the remix of that delicious intro track, so please stop copywriting us, YouTube. That's a legit remix there. We've got a newsletter. We've got viral style. Apparently I left my laptop charger in court this morning. That was brilliant, so I'm going to have to buy a new one of those. So please do buy something from the viral style, because got to get some new equipment here. Let's talk about the news while we're at it. Well, we'll see what Twitter does here. It's reloading. But in the meantime, today's program is not going to be about the news. Today's program is going to be going back to basics. You might remember we read that book by Jerry Spence when this program first started. We've read some things about the FBI, their methods of prosecution. What was happening with Elon Musk? Oh, right. That's political. We don't want to talk about politics. This is a legal program. Monkeypox cases are spreading in Europe and the U.S. This should date this show, right? So we're not going to talk about the news, but those headlines should at least tell you where we're at when you do hear this years from now. Today we're going to talk about a book called Pleading Out. We're going to read from a book called Pleading Out: How Plea Bargaining Creates a Permanent Criminal Class. Let's just front this, okay? Dan Cannon is the author of this book. Dan Cannon is a civil rights lawyer and a law professor at the University of Louisville in Kentucky. In his practice, he has served as counsel for plaintiffs in the U.S. Supreme Court case Obergefell v. Hodges, which we talked about a couple weeks ago when we were talking about the Supreme Court overturning Roe v. Wade. So he was plaintiff's counsel in Obergefell v. Hodges, which brought marriage equality to all 50 states. And in a number of other high-profile cases. He lives in southern Indiana. Point being, this guy is plaintiff's counsel establishing gay marriage. This is an unabashed liberal writing this book. And I don't care. This is a brilliant book. You're going to hear a lot about the usual white guilt stuff, you know, this whole system's against black people and it's racist and so on and so forth. Whatever. It's true. What he is pointing out is true. The system of plea deals, he is correct in his assessment, and that's what is important today, and I would hope that right wing, left wing, and everyone in between can agree with what we are about to read today. It is egregious what has happened to the criminal justice system if you can still call it that in this country. He maps it out well, the development of how this happened. He points out, please tell me my microphone is on. All right. All right. So, good afternoon, everybody. Good afternoon, Ashley. Brian, might still be morning out where you are. I don't know. Storm Hunter. Not political, but very insightful nonetheless, says Pillids. Thank you very much. Good afternoon, says Gigi. It was great to see you on JF's show the other week. Yeah, JF Gary Epi. Awesome show. I love that guy. He had me on a couple weeks ago. I don't really do interviews anymore, but JF is a stand-up guy. And went super fast. Next thing you know, I look up and it's been an hour. So really great interviewer and a great guy. So, all right, sound is good, everybody says. So let's get back to the book here. Pleading Out: How Plea Bargaining Creates a Permanent Criminal Class. You've heard me talk on this program a lot about our system, about the adversarial system, about the jury system, about all of its well, maybe not all of it. I could not exhaust my commentary about the adversarial system and the jury system, but you've heard me talk a lot about some of the flaws in this system, and we have argued here at Crime and Punishment for a return to trial by combat, because you might as well. If you're trying to judge truth through the system that we have, yes, to be fair, to be charitable, we have been developing rules of evidence for 1,000 years, rules of court for 1,000 years. We've been developing these things to make sure that defendants are not prejudiced by garbage being thrown in there by prosecutors, unethical prosecutors, I should say. Not all prosecutors do this. But we have these rules to keep garbage out of trials. Nonetheless, it is a deeply flawed system. We've never really talked about the plea system before. I have complained about it a lot, and I've talked about my experience both as a criminal defense attorney and as an inmate watching men take plea deals to things they did not do. And it's almost always because their lives are being wrecked on the outside. There's nothing they can do to stop it. The longer they sit in there, the more they're losing. They're losing their truck, which is being repossessed. They're losing their apartment. They're being evicted. They're losing their children, who are being taken by child services or the other parent who's taking advantage of the fact that this person from whom they have been divorced is now in jail. This happens every single day in this country. I would dare say in every single jurisdiction in the country. You don't see it. It doesn't make the news. But this is how the system works. And Mr. Cannon is going to point that out, that prosecutors will routinely put people in jail without bond, hold them there literally sometimes for years without bond, to force them to take a plea deal. How did we get to that point? Especially when Mr. Cannon points out we didn't used to have pleas in the United States. That was a total aberration when someone would just give up their right to a trial and take a plea deal. He's going to point out a case where the court literally questioned the guy's sanity. What do you mean you don't want to make the state prove the case? What do you mean you don't want to be put on trial? What do you mean you just want to admit that you did it and take a guilty plea and be hanged? What is wrong with you? We used to not have this system. It was developed in the early 19th century, but that's enough commentary for me. Let's just get into this thing. Let's talk first about this. Criminal charge stacking. This is Florida Treasure talking. And the comments here. Criminal charge stacking is when a police officer or prosecutor charges as many crimes against the defendant at once as they can. Yeah. They will also charge far higher, far graver crimes than anyone believes were committed, so that they can throw decades of prison in your face and say, well, how about this deal? We'll plead down to crime X, which is probably what the defendant actually did, and you take a plea to that and don't go to trial, and we'll give you the sentence you would probably actually get at trial if we charged you justly and correctly with what we think you actually did. That's prosecution 101, baby. For instance, let's say you've got a petty theft case, right? Let's say your guy stole $100 allegedly from, I don't know, Walmart. Petty theft. Prosecutor says, all right, I tell you what, we're going to charge you with grand theft. So now you have a felony, not a misdemeanor that you're looking at. You have prison time you're looking at. You don't want that. You're not an actual criminal. I don't know what happened. Maybe the guy, maybe he was hungry, stole a loaf of bread, got charged with petty theft, or should have been charged with petty theft. I don't know. A million different scenarios could have happened. Somebody walked out with bread or a toy. I don't know. Things happen all the time, right? You have committed a misdemeanor, allegedly. Prosecutor, however, charges you with a felony. The point of that is not that they really think that this Ninja Turtle or whatever you stole allegedly is worth whatever the threshold amount is to be a felony. The point is, we're going to charge you with a felony so that you will not make us take you to trial. You will take a plea to the misdemeanor. Again, prosecution 101. That's a ridiculous example. Petty theft and grand theft, those are dollar amounts. That's not really a bargaining chip for the prosecution. But that's just an example. You could do a lot of lesser included crimes. For instance, battery or aggravated battery or aggravated battery with a deadly weapon. Prosecutors will routinely charge higher than they think the guy actually did so that the guy will take the lesser charge and take a plea to it and not go to trial. So that's one of the things that Florida Treasurer is talking about there. Criminal charge stacking. Sometimes they will just throw a whole slew of charges at you. Like, let's say, somebody accused you of grand theft auto. They accused you of stealing a car. Well, they're also going to add in a burglary of a conveyance. They're going to add in a petty theft because there was something else in the car, or they're going to add a vandalism charge because you allegedly squealed the tires, and left a mark on the road. Like, just whatever they can come up with. They'll stack all those charges so that you'll take a plea to something. Prosecution 101. So this, about pleading out, and I say this not to attack other lawyers for pleading out their clients. This is just the business now. This is how it's done. You don't plead out your clients because you're selling them out. You plead out your clients because of what Mr. Cannon is going to point out is a trial penalty. You are penalized for taking a case to trial. Now, you shouldn't be. Morally speaking, legally speaking, you have the right to a trial by a jury of your peers. You have a right to take it to trial. You do not have to enter a plea. But practically speaking, everybody knows it's a dirty, open secret. If you take it to trial, the judge might be mad. The prosecutor's definitely going to be mad because you should have taken the generous plea that they offered you instead of making them waste their time taking you to trial. So I say it not as an attack on other criminal defense attorneys. Everybody does it. You have to do it because if you don't and your guy really is guilty or there really is a bad case, you're really throwing your own client under the bus by refusing to enter a plea and saying, no, you have to take this to trial. Really, it's the defendant's decision. It's not the lawyer's decision. And many times it is in the client's best interest or the defendant's best interest to take a plea. So this is not intended as blanket statements. Nothing on this program is ever intended as legal advice. You should always consult with your own attorney in your own jurisdiction. But this is not blanket advice. It is not an attack on criminal defense lawyers. This is a criticism of the system itself. Introduction. November 20th, 1972 was a crisp fall day in eastern Kentucky. The leaves had turned their final shades of rust and yellow. The air was clean and cold in the city, Not cold enough to herd people into heavy coats and knitted scarves just yet, but the kind that chills the lungs even to sharpen the senses. Enough to sharpen the senses, excuse me. Officer Cecil Mobley got word from the neighborhood grocery store's manager about some suspicious characters. They were trying to buy dog food and cigarettes with checks that didn't look right. Mobley, off-duty but working security, went to the front of the store, where the manager pointed out two young black men. A rookie in the Lexington Police Department, Mobley couldn't afford to screw this up. He walked right up to the two and demanded to know where they got the checks they were using. They said they found them. Then Mobley pulled his gun. Paul Lewis Hayes was one of the two men arrested that day. At his second court appearance, the prosecutor insisted that Hayes engage in plea bargaining rather than go to trial. The prosecutor offered him 5 years on the charge of uttering a forged instrument, signing a check that he shouldn't have signed. Hayes' story was that he was asked by his alleged partner in crime, a man he had never met, to cash a check for him in exchange for a few dollars in gas money. Hayes said that, "I figured because my brother knew him, I thought that check was a good check because I never did look at it, the check real good, you know." Hayes had been in some trouble with the law before, so he was in a compromised position. Still, he had a family to support, and steady work as a horse transporter. 5 years seemed like a lot of time for a bad check. He didn't want the deal. So, a few things going on here. One, he has a criminal background. Sometimes, again, there are no blanket statements in this episode except for that blanket statement. There are no blanket statements here. Everything is case-by-case basis, right? But sometimes I will advise a client that you don't want to take a plea deal to this if you can win, because if you take a plea deal, I've seen it 1,000 times before. If you take a plea deal to something you didn't do, and years down the road somebody else accuses you of a crime, you might get a withhold of adjudication, which means you don't have a conviction. At least that's what we call it here in Florida. You might get a withhold. You might not have a conviction. You might even get it expunged. You might walk away. It looks like nothing ever happened. But years from now, some cop like Officer Mobley accuses you of a crime. You better believe that that former case is going to come back to haunt you. They're going to say, not just he has a record, but he got away with it last time. He got away with it. He walked. We were lenient on him last time. This time, we've got to throw the book at him. That is how cops and prosecutors look at it. Not, he took a plea deal to something he didn't do because he was looking at prison time, and this was in his best interest. It was the best thing he could possibly do, and he was losing his car. His daughter couldn't get to daycare. His life was falling apart. They were getting evicted, so he took a plea. They don't look at it like that. They look at it as he took a plea and walked away unscathed. We've got to put this guy away this time. That the first time might be a freebie, but if anyone like Officer Mobley, comes along years later, as in this case with Mr. Hayes, boy, you got something coming at you. So that's the first thing to consider if you are considering taking a plea to something you didn't do, is what happens years from now when it happens again. What else is going on here? This is presumably a white cop in the Lexington Police Department in 1972 just picking on two black men. Well, turns out it was a forged instrument. No doubt about that. The crime of the cop was really not the cop's fault. The cop was alerted to a crisis. There's an actual crime did occur. He arrests these guys, right? What is messed up about this case is what's about to happen. What is the prosecutor going to do with this case? That's the crime here. Remember, this is 1972. You might think, oh, well, that was a long time ago. Well, that was a racist system back then. Things like this couldn't happen today. This must have been a one-off thing. No, what is about to happen in this case happens every single day in this country. I promise you. Frustrated by Hayes' refusal, that is, his refusal to take 5 years of prison for a bad check, the prosecutor upped the ante by threatening to slap him with additional charges under the state's habitual offender statute. That law, which I will not name the slang because this is a family-friendly program and the slang is profanity, that law was meant to teach a lesson to anyone convicted of more than one felony offense. In 1972, this law carried a mandatory penalty of life in prison. Hayes' co-defendant was offered a similar deal and took it just so the prosecutor wouldn't put the slang word on him. Worse, the deal required him to testify against Paul, making the pressure to plead guilty even more intense. But Paul insisted he was innocent. He wanted a trial. Recap of this paragraph here, this part of the story. Hayes is offered 5 years in prison for this bad check. He refuses the deal. So the prosecutor says, okay, let me tell you this. If you want to refuse the deal, I'm going to put this habitual offender statute on you, and you're going to be looking at life in prison. So you either take this 5 years, or I will take you to trial and convict you. If you make me go to trial, I will convict you, and you will go to life. You will go to prison for life. Those are the stakes. You either accept the 5 years, or I will put you in prison for life. Prosecution 101. Hayes wanted a trial. A man of his word, the prosecutor piled the additional charge on Hayes and sought to put him away for life. It was Hayes, not his lawyer, who brought the prosecutor's tactics up at trial. He told the jury, this is presumably on cross-examination because he says, just wait a minute. I've seen people that has been to the penitentiary 7 and 8 times out of this very court and everywhere. How come all these people that have been in prison is walking the streets that was 7 and 8 time losers? How come this man offered me a 5-year plea on a cop-out? That is what I don't understand. I have had only one number on my back, referring to his one previous incarceration, and you want to put me away for the rest of my life. I said, I'm going to take my odds with the jury, and that is the reason I am sitting here today. Later, the prosecutor would scold Hayes on the witness stand, asking, quote, isn't it a fact that I told you if you did not intend to save the court the inconvenience and necessity of a trial, and taking up this time that I intended to return to the grand jury and ask them to indict you based upon these prior felony convictions? End quote. Isn't that revealing? Save the court the inconvenience. How dare you, Mr. Hayes? How dare you? How dare you inconvenience the court by insisting that we, the government, must prove that you committed a crime? How dare you? Life in prison. Hayes was convicted. And because of the sentencing laws in Kentucky at that time, the jury had no choice but to sentence him to life in prison for a check worth $88.30. He was 29 years old. Again, you might think this is just a racist thing that happened in 1972, can't happen again. I literally have a case right now where my guy was offered 5 years, and he said, that's ridiculous for the charge, which I won't go into because I'm not identifying cases on this program. But he said, I'm not taking it. Prosecutor said, okay, all right, if you don't want to take those 5 years, I'm going to up this charge. I'm going to up that charge. I will convict you on charge 1. That's a minimum of 5 years right there. And we're going to go to trial on count 2. And I'm going to put you in prison for 30 years. So you either take the 5 years that I'm offering you right now, or if you inconvenience me and you inconvenience the judge and you insist on a trial, I will put you in prison for 30 years. That's a live case right now, 2022. So don't think that this is 1972 with some rookie cop or anything of the sort, or some corrupt prosecutor. This is how the system works. You either take what we are offering you, you fool, or we're going to up the charges, up the ante, take you to trial, convict you, and you'll be looking at 30 years instead of 5. Or you'll be looking at life instead of 5 years. Take the 5 years, whether you did it or not. Because we know you did it. We've been prosecutors long enough. The U.S. Supreme Court upheld Hayes' conviction in 1978 under the case name of Bordenkircher v. Hayes. The court found nothing unconstitutional, or even particularly unfair, in smacking someone with a life sentence for having the audacity to demand a trial. In fact, Justice Potter Stewart's opinion speaks fondly of the mutuality of advantage that plea bargaining gives both defendants and prosecutors. The prosecutor's job, according to Justice Stewart, is to persuade the defendant to forego his right to plead not guilty. Because Hayes was not persuaded, he had to spend his life in prison over an $88.30 check. That's just part of the game, said the court. Say what you will about Biden's pick for this newest Supreme Court justice, but being a public defender, I think, is actually her strongest qualification. One of the things about these older, and I don't mean older people on the bench now, I mean older Supreme Court justices back in the day, the 70s, or even the early 20th or late 19th century. Like, you think of Oliver Wendell Holmes, this giant of American jurisprudence. Like, what real world experience did he have? Was he a grocer? Was he a janitor? You know, President Garfield, he was a janitor at his university. Did you know that? That's a fact. But a lot of these Supreme Court justices, not today, I'm not talking about the present court, I'm talking about these people like Justice Potter Stewart saying, well, there's nothing unfair about this. There's a mutuality of advantage in plea bargaining, and the prosecutor's job is to convince the defendant to forego his right to plead not guilty. Let me ask you what real-world experience Justice Potter Stewart might have had before ascending to the bench of the United States Supreme Court. I would gander to bet next to none. These are the types of justices who go from high school to college to law school to a federal clerkship to becoming a federal judge to becoming a U.S. Supreme Court justice. That is their life. That is their career path. They've never had to go hungry. They've never lived in the hood. They've never had to even be friends with people who have taken plea deals. If you're clerking for a federal judge, you're not dealing directly with criminal defendants. You don't know them as real people. You know them as cases. And that's a criticism of appellate lawyers, a criticism of, and by criticism, I really mean critique. That's a critique of the system, not of them as human beings. But this is just the reality of the situation, that if you go from law school to clerkship to being a judge to being a Supreme Court justice, you don't have the real-world understanding of what plea bargaining means, or why someone would take a plea to something they didn't do, or why someone would refuse to take 5 years in prison for an $88.30 check. So this Supreme Court justice really believes there is nothing unfair about life in prison for an $88.30 check because there's a mutuality of advantage, and this fool should have just given up his right to plead not guilty, should have just taken the plea. He didn't do it. He's an idiot. He gets life in prison. That's his fault. His fault, his problem. So say what you will about Biden's pick for the Supreme Court justice. Personally, I think a public defender on the Supreme Court is a great thing. We should have more criminal defense attorneys who actually went in criminal defense and practiced and know about these things in real life on the Supreme Court. if you ask me. Although Hayes was unlucky enough to get a life sentence for a bad check, he was at least lucky enough to return to a semblance of a normal life. He made parole on the first try, 9 years after his conviction, with the help of Vince Aprile, the lawyer who represented him before the Supreme Court. After making parole, Hayes went back to transporting horses. He died in a car accident a few years later while moving thoroughbreds across Kentucky. In Hayes' parole application, Aprile included newspaper clippings from all over the country. Newspaper clippings of prosecutors expressing outrage over what the Kentucky prosecutor had done. Those prosecutors insisted that they would never have punished a defendant for insisting on a trial. Never. As my son Odysseus would say, never, ever. But in the decades that followed, it became apparent that this wasn't true. Bordenkircher v. Hayes became part of a permissive legacy that began in the dark corners of courthouses and was ultimately blessed by judges everywhere. One that allows prosecutors and other players in the system to punish anyone who refuses to engage in plea bargaining with what is now commonly referred to as a trial penalty. Paul Hayes was at the receiving end of a tactic handed down from British nobility to Boston's high society, one that was intended to keep the laboring classes pacified and divided. Hayes led a difficult life by any measure. He did not live out his days in prison, but he was hardly free. He lived and died as a member of the lowest class in U.S. society, the criminal class. An uncontrolled system of plea bargaining helped put him there. What an introduction of an introduction. Look, leave the Marxist stuff aside, right? Keeping the laboring classes pacified and divided, whatever. Maybe the British nobility had an interest in keeping the working classes pacified and divided. Maybe that's the origin of plea deals. Maybe. Okay, whatever. It doesn't matter. It doesn't matter whether you agree with his assessment, which appears to be Marxist. It doesn't matter if it's true or false. The fact is, this is the plea system, and his assessment of the present state of the plea system is accurate. He is a criminal defense attorney. I'm a criminal defense attorney. He is clearly a Marxist, if you ask me. Obviously a leftist. Plaintiff's counsel, for those of you who are late, for the case that established gay marriage in this country. And he and I have the same exact view of the plea system. That should be very telling. So, we're at 1533. I want to go to this part explaining the history of how plea bargaining came into existence. Well, let's look at this first. Let's look at the comments here. I haven't been reading anything. Sri Lankan social collapse, food riots, MP beatings, zero fuel coming to a town near you. This is just the beginning. This is Beer Hall Pooch. I love dogs. Good evening, Mr. Pooch, says Padfa. The judges, bureaucrats, and justice agencies are corrupt and wicked to the core. Time for a salon to clean house, says Love is Everything. That may be the first reference I've ever seen to Salone in polite society. And I'm not endorsing or agreeing with that statement, but there is a lot of corruption. Let's see. MPs, members of parliament, not military police, so I'm assuming Mr. Pooch is from England. I don't know anything about the English system at present, so I will not comment on that. Plea deals lead to corrupt short-circuiting of the scrutiny of the justice system, says Padfa. Yes, there's a lot of corruption in the plea deal system. One of those you've just seen, and as he pointed out, the author, that is Mr. Cannon, this is not something that was a one-off. This is something that has become a feature, not a bug. This is what the police system is now. Because these prosecutors were all saying when it happened, oh, I would never do that. We would never punish a man for taking a case to trial. Happens every single day. Every day. It's not even an ethical question anymore. It's just part of the system. They will always get their pound of flesh, guilty or not. Not always. Not always. There are, cases that get dismissed. There are ethical prosecutors out there. This is not a question of ethics at this point in this constitutional American legal game. It's not an ethical question. This is how the system works. And as a prosecutor, you do have bosses. You don't get to just make your own decisions on things. And sometimes the office policies, trial penalty is one of those office policies. So let's go to part 1, chapter 1, which is titled Brahmins, Bargains, and Bootmakers. We've only got 25 minutes left, so let's skip ahead to there because I want to talk about the history of how plea bargaining came into being. Until the 1830s, someone like Paul Hayes could not have suffered a trial penalty for refusing to take a plea deal before trial, because there was no such thing as a plea deal. Before that time, that is the 1830s, official wrangling over criminal penalties was long considered an aberration, with scant historical evidence that any jurisdiction maintained the practice for more than a brief period of time. Guilty pleas themselves were extremely rare. Defendants had no incentive to admit guilt, and courts were hesitant to let people plead guilty even when they wanted to. In fact, the earliest reported instance of an American guilty plea suggests that courts were doing their best to talk defendants out of confessions and into trials, even for the most horrendous crimes, regardless of whether those defendants received anything in exchange. Quite the opposite now. I have a story I'll tell you some other time, but at this point, I have personal experience with a case where the judge was talking the defendant into taking a plea rather than go to trial because the plea was just so good. You're crazy to go to trial. Of a man accused of raping and murdering a 13-year-old girl, a court wrote this in 1804. Quote, "The court informed him of the consequences of his plea and that he was under no legal or moral obligation to plead guilty, but that he had a right to deny the several charges and put the government to the proof of them. He would not retract his pleas, whereupon the court told him that they would allow him a reasonable time to consider of what had been said to him and remanded him to prison. They directed the clerk not to record his pleas at present. The court examined under oath the sheriff, the gaoler, and the justice, who had conducted the preliminary examination of the defendant, as to the sanity of the prisoner, and whether there had not been tampering with him, either by promises, persuasions, or hopes of pardon, if he would plead guilty." Now, that is, thankfully, something that we have retained to this day. So now that we do have plea deals as a matter of course, as just part of the system, you go through what's called a plea colloquy. If you take a plea, the judge, well, first of all, you got to sign the paper. It's on paper. It is a written document where you put, this is the offer. This is what the sentence is going to be. This is what the state and defense counsel have come up with. This is what we've agreed to. You hand that written paper to the judge, and the judge is going to go through the plea colloquy. The judge is going to ask you a bunch of questions. Again, just did this morning. Judge will ask you, your name for the record, ask you, are you on drugs? Have you been drinking alcohol? What's your highest level of education? Do you understand everything that's being said here today? What is your proficiency in English? What level of grade school or what level of education you have? Just to make sure that you understand what is going on. That's one realm of questioning in the plea colloquy. Another area of questioning is what we're talking about here in the book. Whether there had not been tampering with him, either by promises, persuasions, or hopes of pardon if he would plead guilty. So the judge will ask a defendant directly, has anyone promised you anything that we have not already talked about? Have they threatened you? Have they coerced you to sign this document? Or are you signing this voluntarily and of your own free will? This morning, it was funny. The judge actually asked, did anybody do any of this stuff that would shock my conscience to hear? And that's kind of it, right? So if somebody says, yeah, I promise, man, we'll watch the game. You get probation, you get out, we'll watch the UFC fight or whatever. That's not something that's going to shock the conscience. That's not obviously what the judge is asking about. If someone said, you're going to take this plea deal, or we're going to go to child services and have your children taken away from you. You understand? That would be something where obviously this guy was coerced to take the plea deal. I wonder if an inmate ever said, yes, they said they would let me out of jail where I've been confined and forced to take this plea deal. I don't think that would shock a judge's conscience anymore. That's just part of the game. They keep people in there without bond to force them to take plea deals. That's just how it goes. You don't like that? Take it to trial. What was the other thing I was going to comment upon here? Would not retract. Oh, right. Whereupon the court told him they would allow him a reasonable time to consider of what had been said to him and remanded him to prison. So they didn't even allow him to take the plea right then and there. They were so concerned by this guy saying, no, I just want to plead guilty, that they wouldn't even accept it there. And more than that, they questioned the sanity of the prisoner, questioned whether he had been tampered with. They refused to allow him to record the pleas. They directed the clerk not to record his plea. So they wouldn't let him record it. They questioned whether he was sane and started examining everybody about it. They sent him back to the jail to make sure he could spend the night thinking about it. That is how concerned they were that this guy was crazy for taking a plea. This was, of course, before being penalized for taking something to trial. So it was a different picture back then. But that's how concerned they were that someone would just give up their right to a trial. It was crazy. Actually crazy. So, the court eventually accepted the plea, and the defendant was promptly hanged. Again, this was the rape and murder of a 13-year-old girl. So, obviously, he was hanged. Oh, well, I guess it's not obvious anymore, but this was 1804 when that was obvious. You are hanged for something like that, which is part of the reason, I suppose, they thought he was crazy. But the court eventually accepted the plea, and the defendant was promptly hanged. But the acceptance was a reluctant one, even when no bargaining was involved. Massachusetts was the fertile crescent of plea bargaining, and although we don't know much about the genesis of the practice per se, we do have records of the raw number of guilty pleas in Boston. Throughout the 1830s, this number increased dramatically, suggesting that defendants had an incentive to plea that wasn't there before, and that courts were less reluctant to accept those pleas. For a while, the new practice of plea bargaining was a dirty secret of the biggest cities in England, rarely put in writing or spoken aloud. Even after the practice became commonplace, the question of whether it was legal to openly entice or coerce someone to give up the right to a trial remained officially unsettled for years. Judicial opinions from the 19th century consistently and repeatedly affirmed the idea that, as one Iowa court put it, quote, "There is no right more sacred than the right to a fair trial. There is no wrong more grievous than the negation of that right," end quote. So it's kind of taken for granted here that you are being coerced into taking a plea. There's no way around that. And how we justify it to ourselves, to our consciences, to our peers in the legal profession, we justify it by saying, well, yeah, but it's a legal threat, right? They're not coercing you illegally. When they up the ante, they increase the charge, they amend the information to add new charges or to raise it from a misdemeanor to a felony or from a third-degree felony to a first-degree felony. That's all legal. They have the power to do that. They have the right to do that as the state. That's not coercion. By coercion, we mean, did somebody put a gun to your head? Did somebody threaten your family? And I've seen that too. I remember vividly a case here in Florida. Kid was charged with, it was a drug charge. They wanted to force him into what is called a substantial assistance agreement, which is basically you get your charges dropped if you help the cops set up other people. He refused to do it. And then the cops said, well, you know what? I could always go to this other state. I don't want to name any details. That's why I'm not saying what he was charged with or trying to leave out as much detail as possible. I will go to your girlfriend in the other state and I will arrest her for trafficking. Because she was involved, wasn't she? She's pregnant, isn't she? And we can extradite her here to Florida and charge her with trafficking. Well, naturally, the young man decided he was going to enter that substantial assistance agreement. If that is not coercion, what is? If you don't enter into this agreement, we will go to another state, arrest your pregnant girlfriend, and bring her back here and put her on trial for trafficking. Who's not going to agree to that? Obviously, that is coercion. That is the definition of coercion. And yet, that's legal. I mean, she allegedly committed a crime, right? At another case, where, I mean, this is routine. I'm not even going to get into it. But the phenomenon of a prosecutor threatening the wife or girlfriend or mother of a defendant, saying, you, defendant, will enter into this agreement or we will go after this woman who is the mother of your child or who is your wife. We will go after that woman if you don't enter this plea. That's the definition of coercion. Happens every day in this country. So when they're asking you in the plea deal, has anyone promised you or threatened you to enter into this plea, you're going to say no. It's kind of like one of those, terrorist videos, right? Like they're holding a gun to the person's head and the person's like, I am fine. I'm definitely not being held hostage. No, of course, Your Honor, nobody threatened me to enter into this plea. I'm doing it freely and voluntarily. You don't tell the judge, yeah, the cops said they were going to arrest my pregnant girlfriend if I don't enter into this agreement. You can't tell the judge that, because then it's over. Then they're going to go arrest the girl. Anyway, in Massachusetts, this issue was still being sorted out as late as 1845. One Boston prosecutor, Asahel Huntington, I don't know how you would pronounce that in English in 1845, Asahel Huntington, was himself prosecuted. One Boston prosecutor, we'll say Mr. Huntington, was himself prosecuted for offering lenient fines in liquor cases in exchange for guilty pleas. But Huntington was exonerated of any wrongdoing. In one of the first examples of any institution explicitly approving plea bargaining, the practice was wholeheartedly condoned by the state legislature's report in Huntington's case. Quote, this course was not only known but much and justly approved as tending more than any other course in the class of cases to which it was applied, to attain the just end of all punishment, the prevention of the offense, the reformation of the offender, end quote. In other words, it was a canonical fact that plea bargaining was good for all. Despite his prosecution, Huntington enjoyed a long and successful career in Massachusetts politics, a testament to just how established the idea of bargain justice had become in the state in such a short time. In other words, Huntington was saying, I will lighten your fines here if you just plead guilty. Well, looking back now from 2022 at this practice in 1845, well, naturally, prosecutors do that all the time in probably every case except the ones they really want to hang you on, right? And you don't get a plea offer. That happens sometimes, but otherwise, of course, they always offer lesser sentences, lesser fines in exchange for you pleading guilty. That's what pleading is. The floodgates, that is in 1845, had been thrown open. From the 1840s, on the speed at which plea bargains replaced jury trials, from the 1840s on, the speed at which plea bargains replaced jury trials is astonishing. Guilty pleas, once practically unheard of, accounted for the disposition of more than half of all criminal cases in Boston by 1850. So, in just over a decade, more than half of the criminal cases were pled out. So going from there's no such thing as a plea deal in 1804 to by 1850, half of criminal cases are resolving in plea deals, that's huge. And it took 50 years to get there, but in the 1,000-year, the 800-year course at this point, from the invasion of William of Normandy to 1850, 50 years really is a short time for such a dramatic turnaround. By 1880, the number had increased to 88%. 88%! 88% of criminal cases ending in plea deals. Can you imagine what that percentage is now? I thought it was on the back of the book. I was turning it over dramatically. Anyway, somewhere else in here he's going to say it. Let's see if I can... Spoiler alert, it's like 98% of cases are resolved by plea deals now. So from zero, because it was unheard of, to within 50 years, half of the cases, to by 1880, 88% of cases are resolved by plea deals, to now 97 to 98% are resolved by plea deals. That is a dramatic change in the legal profession. And we, ladies and gentlemen, we were born into it. This is our system. The practice quickly spread from Boston to the rest of New England, and it soon became part of everyday criminal justice all over the country. Just 100 years later, a centuries-old tradition had all but curled up and died. Although criminal prosecutions dramatically increased throughout the 20th century, criminal trials dramatically decreased, both as a percentage of cases overall and in actual numbers. In other words, throughout the 20th century, there was a massive increase in criminal prosecutions. Well, of course there were. There's an influx of people. There were more laws, ergo more crimes. A lot more criminal prosecutions. However, not just the percentage of criminal trials, but the number of criminal trials, even considering all of that increase in population, even considering the increase in the criminal prosecutions, still the number of trials declined. That's crazy. Because everybody was pleading out. By the time that Paul Hayes was convicted in 1972, jury trials were not just uncommon, they were seen by nearly all prosecutors, defense lawyers, and judges as an annoyance, one for which an accused could pay dearly. Today, trials are, statistically and practically speaking, an artifact of the past. What happened in the 1830s and 1840s that put quick and dirty judgments in the driver's seat, pushing jury trials to the back? How and why did haggling over the freedom of human beings, a practice still abhorrent to many legal systems in the world, become essential to U.S. criminal justice? This chapter begins to answer those questions by tracing the emergence of class conflict and the corresponding rise of plea bargaining from 17th century England through the middle of the 19th century in the United States. So, again, yes, he is obviously a leftist, most likely a Marxist from what I'm hearing, but that doesn't matter. His assessment of the plea bargaining system is accurate. You know that if you are in criminal defense. You should know that if you're a prosecutor, and I presume every judge knows this. This is the state of affairs. This is how the plea system works. So, are plea deals, asks Mr. Pooch, are plea deals ever beneficial to the accused? Say if he's willing to sell out his accomplices. Plea deals are often beneficial to the accused, yes. So, like I said, this is not lambasting anybody for taking a plea deal. I'm definitely not criticizing people who take plea deals. I'm not even criticizing defense attorneys for advising their clients to take plea deals. In fact, as I mentioned, I was at a plea deal this morning. I'm not even criticizing prosecutors for offering plea deals. What we're pointing out here, and what this entire book is about, and again, the book is called Pleading Out, How Plea Bargaining Creates a Permanent Criminal Class. What they're pointing out is this system is deeply flawed. To answer your question directly, Mr. Pooch, yes, plea deals can often, and are often, they can be beneficial to the accused. Yes, absolutely. I mean, if you are looking at, a minimum mandatory, here in Florida, we have certain crimes that are minimum mandatory sentences. Like you sell X number of drugs, or you're accused of crime Y, and you are convicted of that, you're looking at 20 years in prison, minimum mandatory. That means the judge has no discretion. The absolute minimum the judge can sentence you to is that statutory minimum of 20 years, right? So if you are offered 5 years, then yes, obviously that is beneficial to you. In the case of Mr. Hayes pointed out in this book, the plea deal was beneficial to him, right? Either you take this 5 years, or I'm going to put you in prison for life on a habitual offender statute because you are inconveniencing us all by going to trial. So yes, the plea deal was definitely beneficial to him. Taking 5 years instead of life in prison? Oh, yeah. If you are looking at 5 years in prison and the prosecutor is offering you probation and you did it, oh, yeah, absolutely. Plea deal is beneficial to you. So again, state case-by-case basis. Ask your lawyer. Do not take this program as legal advice. Case-by-case basis, plea deals can be good for you. They can be horrible for you. Trial penalty is real, though. So read this book, Pleading Out. Yes, it's by a rabid leftist, but it is an accurate criticism. So, any more questions? Money, and that can be interpreted in terms of class, says Padfa. Yeah, I mean, it's not like class conflict doesn't exist. I mean, we're not that right-wing, right? We here at Crime and Punishment have no political opinions at all, but we're definitely not signing on to the Marxist program. So until next week, everybody, maybe we'll bring up the news again. I don't know. We'll see you then.